The title of this video was Own Nothing, Control Everything, the Rockefeller Strategy Explained. And in the next 60 seconds, I'm going to show you the single sentence that separates I have assets from I have defensible assets. So here's the problem. If your name is on the wrong line of the wrong document, your life can look successful right up until the day a lawsuit, a divorce filing, a partner dispute, or a business blow-up turns your net worth into a menu. And the plaintiff's lawyer doesn't care that you're a good person. They care that you're collectible. And here's the promise. By the end of this video, you'll understand how sophisticated families and sophisticated business owners structure their lives so they can still control their business, real estate, and investments without wearing a giant "Sue Me" sign on their chest. And here's the path we're going to take. I'm going to give you a simple framework in 3 layers: ownership layer, number 2, control layer, and number 3, protection layer. So you can see exactly what goes where and why it goes there and how it stays legal. And yes, I'll show you the most common Rockefeller mistake that people make when they try this, which quietly hands control right back to a U.S. judge. Now, quick credibility so you know where I'm coming from. I'm the business guy with the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection field for 35 years, and I've been setting up Cook Islands trusts for about 30 years. And they've told us we've set up more of them than any firm in the world. And I'm not here to sell you hype. I'm here to teach you how the chessboard actually works. Okay, now let's decode the phrase because it's really misunderstood. Own nothing doesn't mean be broke, lie, or hide assets. It means don't personally own things that create risk if your personal name is sued. Control everything means keep legal control through contracts, operating agreements, management roles, and trustee mechanisms so you can still run your business, collect income, and make investment decisions while separating your personal name from the assets that get attacked. Think of it like this. Ownership is the headline in the news article. Control is who has the remote. If your name owns it, your name gets subpoenaed. If your structure controls it, your structure gets challenged, and structures fight differently than people do. Here's a micro cliffhanger payoff. The sentence, asset protection, is not about hiding assets. It's about separating benefit from liability. And if you remember that one sentence, the rest of this video will click. Chapter 2, why being successful paints a target. So let's talk reality. In the U.S., lawsuits are not rare events. State courts alone see tens of millions of filings per year, in the order of about 70 million in 2024, according to the National Center for State Courts. And even if you're not a small business, the dynamic is the same. When you have employees, customers, tenants, partners, or a public footprint, you have friction. And friction plus money equals lawsuits. Now, you've probably heard the stat that a big chunk of small businesses face litigation in a given year. The exact percentages vary by study, but the pattern is consistent. Legal exposure is not a maybe, it's a win. Okay, now let me give you the uncomfortable truth. The plaintiff's attorney is not guessing what you own, they're searching. They search the public records, they search your deeds, they search your LLC filings, they search your UCC1 filings, they search your social media because people post the evidence, and if the assets are in your personal name, the legal system can often reach them with alarming simplicity. So this is where the Rockefeller-style thinking kicks in. Sophisticated families realize something early. If wealth is held personally, it's fragile. If wealth is held institutionally through entities and trusts, it becomes durable. And by the way, this is not some secret billionaire wizard spell. It's paperwork, governance, and timing. Okay, cliffhanger number 1, in about 3 minutes, I'm going to show you the 3 buckets test that instantly tells you if your current setup is lawsuit friendly or lawsuit resistant, and most people fail it in under 30 seconds. Chapter 3, the 3 buckets test: ownership, control, and protection. All right, here's the 3 buckets test. 1, 2, 3. Those are buckets. Imagine 3 buckets on the table. Bucket 1 is the stuff, assets. That's your stuff. Bucket number 2, hands. That's your control. And bucket number 3, your shield. That's your protection. Now, I have beautiful writing, I know. Now, most people do this. They put the stuff and the hands and the shield all in their personal name. So in other words, I own it, I control it, and I'm responsible for it. Now that's neat, but it's also collectible. The Rockefeller-style structure separates these buckets. The stuff, assets, is owned by entities and trusts. The hands, control, is held by managers, officers, and agreements. And the shield, protection, is created by jurisdiction, legal separation, and trustee mechanism. So let's make this practical with a business owner example. You own an operating company. There's a building with a little smokestack on it. A few rental properties. These are rental properties. A brokerage account. You have cash reserves. If all of that is in your personal name or titled under the same LLC you personally manage with one sloppy document, you have one big legal magnet. The better way is to isolate risk by category. Operating risk, the company that interacts with the world. Real estate risk, tenant slip and fall, contractors. Investment risk, market swings and sometimes creditor exposure. Cash risk, the easiest thing for a court to freeze. Now here's the key teaching point. The goal is not to own nothing. The goal is to own the right things in the right place so a lawsuit in arena A doesn't burn down arenas B and C. So think of it like a ship. If you don't have watertight compartments, a leak anywhere becomes a sinking. So what does a smart compartment look like? It looks like this. Operating company sits in a clean entity structure with proper corporate hygiene. Each property sits in a privacy liability setup, often land trust for privacy. So here's a house, house, house. So we have a land trust, land trust, land trust. And every property is in a separate land trust with an LLC as a beneficiary. So the land trust gives you privacy of ownership. The LLC gives you the protection. So investments sit away from operating risk, and they're not titled in a way that makes them easy targets. Personal name owns as little as reasonably possible that can be seized. So notice what it didn't say. It didn't say you transfer everything after you get sued. That's how people turn a bad day into a headache. Timing and intent matter. Cliffhanger payoff. The 3-person bucket test. If your personal name is holding all 3 buckets, you're playing financial dodgeball without a helmet. And yes, the balls are lawsuits. Okay, Chapter 4, the Rockefeller Toolbox. We're talking about holding companies, and we're talking about corporate governance. When people say the Rockefellers, they're usually pointing to a family pattern more than a specific quote. Wealthy families use a toolbox, and the toolbox has 3 big tools. It has holding companies. Instead of you personally owning 10 things, a holding company owns them, so you control the holding company through management roles and agreements. The benefit, you can separate ownership from operation. Number 2, the trusts. The trusts are not just for death. A trust can be for control, continuity, and protection. The trust is a legal relationship that holds assets for beneficiaries under rules. So when designed correctly, it can help prevent a single lawsuit from turning into a forced liquidation. Tool number 3 is governance. Now this is the part that most people skip because it's not sexy. Now governance means operating agreements that actually match reality, minutes, separation of accounts, documented loans, documented salaries or distributions, clean contracts between entities. In other words, the structure has to behave like a structure. Now here's the uncommon insight. Most asset protection plans fail because they're designed like a diagram, not a business. A diagram is easy to sell. A living structure is what actually wins. So let me give you a composite case study. We call this the 1 LLC myth. A successful contractor had a $6 million net worth, operating company, equipment, rentals, brokerage account. Everything sat under ABC Holdings LLC because somebody told him 1 LLC is clean. Then he had an employee injury claim. The plaintiff's attorney did what plaintiff's attorneys do. They look for the deepest pocket. The operating claim became a pressure campaign against the whole empire because everything was connected. He didn't lose everything, but he paid a premium in settlement value because the structure advertised collectability. The lesson, 1 LLC is often 1 target. Okay, cliffhanger number 2 in a minute. I'm going to explain the difference between control and reachable control. And that distinction is why offshore strategies exist at all. Okay, control versus reachable control, why offshore exists. Here's the difference. Control is your ability to make decisions Reachable control is a court's ability to force you to use that control. Got that? Most people have control that's reachable. Example, if you're the manager of your own LLC in your own state and a judge orders you to turn over assets, sign documents, or repatriate funds, the court can apply pressure, contempt, sanctions, or worse until you comply. And that's why own nothing, control everything, that concept often includes a protection layer that is not under U.S. judicial control. So this doesn't mean illegal. It means jurisdiction matters. Now, this is where my world comes in. At Asset Protection Planners and Lawyers Limited, we often design a Cook Islands trust structure with a Cook Islands LLC inside of it. Here's how it works in plain English. When the waters are calm, so a Cook Islands trust owns 100% of a Cook Islands LLC. There's the Cook Islands LLC right there. You, the client, are the manager of the LLC. And the LLC can hold bank and investment accounts. You can do direct investments and day-to-day decisions within the legal framework. So when a lawsuit strikes, the licensed bonded trustee company law firm can replace you as manager if needed. So they become manager of the LLC, because if you remain manager, then somebody could force your hand to turn money over that you didn't want to turn over. So this changes the reachable control equation because the decision maker is no longer a U.S. person that a judge can order around. And critically, Cook Islands law has features designed for this purpose, like requiring creditors to bring a fresh case rather than simply domesticating a U.S. judgment, plus short limitation periods for fraudulent transfer claims and high burdens of proof. That's the core concept. Calm time control, crisis time insulation. Now, to be very clear, structures do not make you immune to legitimate debts, taxes, or crimes. They change leverage. They change process. They change the game board. Here's a cliffhanger payoff. Reachable control is the reason your plan must be built before the threat is real. And it's also why slapping a U.S. LLC inside of an offshore trust is not the magic move that people think it is. Chapter 6, the 4 rules that keep this legal and actually effective. If you take nothing else from this video, take these 4 rules. These are the keep out of trouble rules. Number 1, timing matters. Asset protection is like a seatbelt. You don't put it on after the crash. If you move your assets after you're threatened, you invite fraudulent transfer claims, and that's not asset protection, that's panic. Now, the nice thing is there are things that we can do internationally that can still protect your assets with an offshore trust, but it's best to get this done beforehand. Rule number 2, substance matters. If your LLC is just a bank account with letters in it, it'll be treated like that. Separate accounts, separate books, real contracts, real behavior. Rule number 3, don't mix operating risk with investment wealth. Your operating company should not own your personal portfolio. Your tenants should not be connected to your payroll. You want legal firewall breaks. Rule number 4, separate benefit from liability. Now, you can still benefit from assets, income, use, appreciation without personally wearing the liability. That's the whole point of own nothing, control everything done properly. Now, a quick invitation, because if this kind of practical real-world structuring is useful, consider subscribing. I don't do legal gossip. I do how the system works in plain English for people who actually have something to protect. And a soft resource note, if you want a deeper breakdown of structures like this, we have educational materials at assetprotectionplanners.com. No pressure, just a place to start learning in a more organized way. Okay, cliffhanger number 3. I'm going to walk you through a Rockefeller-style blueprint for 1 to 20 million plus net worth business owners, and I'll show you the exact point where most people accidentally hand a creditor a straight line to their assets. Okay, Chapter 7, a practical blueprint for 1 to $20 million plus. Business owner. Let's build a blueprint, not legal advice, education, but a blueprint. Step 1, identify your risk generators. Operating company, customers, employees, they all work here out of the operating company. Next, real estate. We're talking about tenants, injuries, code issues, and then professional risk. We're talking about fiduciary claims, malpractice exposure, advice, and then there's personal risk, okay? There's things like cars, personal guarantees, lifestyle visibility. Step number 2, create compartments that can match the risk. Common pattern, operating company in its own entity. Each rental property isolated in its own liability silo. land trust for privacy of ownership. The beneficiary is an LLC, and that way each property is in a separate cubbyhole, so the risk is limited to that one property. And then we do equity stripping on that property to pull out the value. A protection layer is built before you need it. Step 3, decide what you personally should own. Here's a surprisingly short list that often makes sense. A modest amount of day-to-day cash, personal effects, possibly a protected residence depending on your state strategy, retirement assets where they already have strong statutory protection. Everything else, consider whether personal ownership is buying you convenience at the cost of exposure. Step number 4, build control intentionally. This is where people mess up. They confuse I can sign checks with I have durable control. Now, durable control means you can replace managers. You can hire and fire. You can direct investments. You have clear rules for what happens when there's pressure. In a Cook Islands trust model, the durable control is built into the trustee step-in mechanism. So you manage when calm, the trustee manages when hot. And that's how this protects you. Step 5, make sure you keep it clean. And what we mean is this. Your structure has to survive discovery. A good plan can be explained with a straight face on a transcript by a professional. Now, here's the exact point where people accidentally create a straight line for creditors. They leave the vulnerable assets in a U.S. entity that a U.S. court can order them to turn over. Remember, the earlier concept we talked about, reachable control. If a judge can force you to move the asset, then the asset is effectively reachable, even if it's technically owned by something else. That's why sophisticated plans pay attention to jurisdiction and control. That's where offshore asset protection planning that we do comes into play. Here's a composite case study, the real estate dominoes. A real estate investor owned 5 properties. Each property had equity, and each property was titled the same way. A contractor dispute on one property turned into a lien and a lawsuit. The plaintiff's attorney didn't stop at the disputed property. They pursued all the properties because they were all owned and controlled the same way. The investor had enough cash to settle, but the settlement number was higher because the leverage was higher. When you separate compartments, you reduce leverage. Here's a cliffhanger payoff, and the blueprint is not complicated. The hard part is discipline, and discipline is cheaper than litigation. Okay, Chapter 8, the control everything mindset. You're building a system, not a shell game. So let's go ahead and zoom out. The Rockefeller strategy, however people attribute the phrase, is really a system mindset. Wealth should outlive lawsuits. And I tell you what, the Rockefeller family as a whole is still wealthy. They still have billions of dollars that has accumulated for the descendants of the Rockefeller family. We just did a video on the Rockefellers versus the Vanderbilts. The Vanderbilts were super wealthy too, and their wealth only lasted 3 generations because they didn't have it set up properly. So wealth should outlive lawsuits. Control should survive emergency. Your personal name should not be the central hub of all assets. Governance should make the structure believable. I'm talking about minutes for the meetings, operating agreement done properly, those kind of things. That's what I'm talking about, governance. So if you're a $1 to $20 million plus net worth business owner, the goal is not to cosplay as a billionaire. The goal is to build a plan that keeps you operating, reduces your settlement leverage, protects your family from a single bad event, as well as making your wealth transferable to the next generation without chaos. That's why trusts and holding companies show up again and again. They're continuity machines. Now, because I've been doing this for 35 years and setting up Cook Islands Trust for about 30, I can tell you what changes people's lives. It's not paperwork. It's psychological shift from I own things to I run a system. When you run a system, you're harder to knock over. And yes, there's humor in that because a lawsuit is basically an invoice from a stranger who's mad at you. The goal is to make sure your wealth isn't the easiest credit card to swipe. Okay, in closing, what to do next? Calm water moves. So what do you do next? Run the 3 buckets test on yourself. What do you personally own? What do you control? What can a court force you to do? Clean up governance. Make sure you've done your minutes for the meetings. Make sure you have the proper operating agreement, the bylaws if it's a corporation. Separate accounts. Update operating agreements. Document intercompany relationships. Compartmentalize your risk. Stop mixing operating risk with investment wealth. If you're serious about a protection layer, build it while the waters are calm. That's when you have options. That's when your structure is strongest, and that's when you're not explaining your choices to a judge. If you want a next step in education, the on-ramp is assetprotectionplanners.com. Again, education first, because good decisions start with understanding. I'm the business guy with a Lawyers Limited law firm and Asset Protection Planners. Thanks for spending these minutes with me, and we'll see you in the next one.